Oh. Assalamualaikum semua.
Assalamualaikum.
Ya. Okay, our speakers are here. So we will start at 2, Datuk. Shah, Dr. Shah.
Okay.
Dr. Shah, can you hear me? Is the line okay today?
Assalamualaikum and a very good afternoon. We bid to our respected guest speakers for today, Professor Dato Dr. Rahmat Muhammad and Dr. Shahrizal Muhammad Zain, to respected moderator for today, the Dean of Faculty of Law, Associate Professor Dr. Hartini Sarifan, lecturers, and attending audience. I, Sarah Binti Azaha, your Master of Ceremony for today, would like to extend a heartfelt welcome to everyone to today's session of the ITM Law webinar series. For today's session, we will delve into the topic of international law in the post-COVID-19 era. Specifically, Professor Rahmat will explain on global health security, while Dr. Shah will discuss on the matter of investment treaty disputes in response to COVID-19 measures. Before we begin, kindly be reminded for the audience to fill in the evaluation form for feedback purposes. And specifically to the UITM lecturers and staff members, do fill in the form for training purposes record. The form link has been shared to the session's chat box. Now, without further ado, ladies and gentlemen, I'll pass the session to our moderator for today, Associate Professor Dr. Hartini Sarifan. Over to you, Dr. Hartini.
Yes, thank you so much, Sarah, for passing me the floor. Assalamualaikum warahmatullahi wabarakatuh, and a very good afternoon. First and foremost, I would like to extend very warm welcome to all of you for joining us today. Welcome to our UITM Law webinar series, and this is a very special session on a very timely issues of international law in the post-COVID-19 era. I hope everyone is in the pink of health and doing well during this MCO period. Despite the order, I remember the quote by Einstein saying that life is like riding a bicycle. To keep balance, we've got to keep it moving. So even at this difficult time, we should preserve with what we do, learning and preparing for the future, not stop despite being faced with this difficulty. So ladies and gentlemen, before we invite our esteemed speakers today, let me just remind you once again, kindly switch off your audio and video function at all times in order to ensure a smooth running of our program. And please write down your question in the chat box for our question and answer session after our two speakers finish their talk. And with that being said, I would like to once again welcome everyone. And today we are indeed very privileged to have two very illustrious speakers who will enlighten us on the timely issues arising from the outbreak and pandemic of COVID-19. On 11 March 2020, the World Health Organization, WHO, declared the COVID-19 a pandemic and called on states to take urgent and aggressive action. In response, states around the globe have been taking emergency measures of differing degrees to seek to limit the impact of the virus, and Malaysia is of no exception. While the countries around the world are taking aggressive measures to control the spread of the virus, the economic impact of this measure has already resulted in a significant slowdown in the global economy, with the full economic shock yet to be fully understood. On another spectrum, balancing public health fears and avoiding economic catastrophe is extremely a challenging task. So ladies and gentlemen, we are very fortunate to have our two speakers who will be covering this important impact of COVID-19. Let me first introduce our speakers today. So I think the Secretariat will be sharing with us the biodata of our speakers. Okay. Let me just open mine. The first speaker yang berbahagia, Professor Dato' Dr. Rahmat Muhammad, needs no introduction. He is indeed the world scholar on international law. However, still, I can't help myself of reading his impressive CV. So let me just read his biodata. Professor Dato' Dr. Rahmat is currently the Deputy Vice Chancellor and Professor of International Law at UITM. Prior to the present appointment, he held the position of the Secretary General of the ASEAN African Legal Consultative Organization, ALCO, for 2 terms from 2008 till 2016. ALCO is an intergovernmental organization with 47 countries from Asia and Africa being members of the organization with its headquarters in New Delhi, India. As Secretary General, he headed numerous diplomatic meetings on behalf of the ALCO, mainly concerning progressive development of international law. In addition, at the annual meeting of ALCO and International Law Commission and the Sixth Committee of the United Nations, he presented the views of member states of ALCO on many international law issues, namely law of the sea, international criminal law, world trade, cyberspace, and violent extremism. As the Chief Executive Officer of the organization, he has successfully revitalized ALCO as an important and relevant regional organization that serves the needs of member states and managed to recover ALCO from severe financial crisis. In addition to that, apart from his diplomatic role, he delivered numerous lectures in many universities around the world and held various academic positions. He has written numerous articles, papers, reports, book chapters, and books on diverse topics on international law. In 2016, he represented Malaysia in the preparatory committee meetings in the United Nations on the draft text of an international legally binding instrument on the conservation and sustainable use of marine biological diversity beyond areas of national jurisdiction, and was nominated by the government of Malaysia as Malaysia's candidate in the 2016 election of the International Law Commission. He was a council watching brief for state government of Johor in the application for revision of Batu Puteh, Pedra Branca's case of 2008 before the International Court of Justice at The Hague. For his outstanding role and contribution to ALCO, he was appointed as a member of Eminent Person Group of ALCO in 2016. On his expert capacity, he was invited to speak on unilateral coercive measures at the UN Human Rights Council meeting held in Geneva in 2019. That's why his CV is very, very impressive. And we are so proud to have Yang Berbahagia Dato' as part of us. And not to mention, Yang Berbahagia Dato' is also one of our alumni. And our second speaker, Dr. Shahrizal Muhammad Zain, he is our rising star. He is the upcoming world scholar. His expertise has been nationally and internationally recognized. Dr. Shah is a legal academic and alternative dispute resolution practitioner. He is an advocate and solicitor of the High Court of Malaya. He was called to the Malaysian bar in 2003 and commenced legal practice in Kuala Lumpur soon after. He is an arbitrator and adjudicator and panel at the ASEAN International Arbitration Center, AIAC. His areas of expertise include domestic and international dispute resolution, with specific reference to construction law, international commercial arbitration, investment treaty arbitration, and international trade matters. He graduated from University of Malaya with LLB Honours and LLM and holds a PhD from Monash University, Australia. He has been awarded a diploma in international commercial arbitration from the Chartered Institute of Arbitrators UK and admitted as a fellow since 2016. He is also a fellow of the ASEAN Institute of Alternative Dispute Resolution. He is currently our very own senior lecturer at the faculty. So, ladies and gentlemen, we have two prominent and illustrious speakers today. And without further ado, let us hear straight from the horse's mouth. And please welcome Yang Berbahagia, Professor Dr. Rahmat Muhammad, and he's going to deliver a talk entitled Global Health Security and Law in the Post-COVID-19 Era, Issues and Challenges. Over to you, Dato'. The Secretariat will share your slides.
Thank you very much, Dean. And let me at the outset express my thanks to the Dean and the host of today's event, the Faculty of Law, UITM, in organizing this webinar on the subject of international law in the post-COVID-19 era. Obviously, it is a very important subject, as the Secretary General of the UN, Antonio Guterres, which he has underlined. COVID-19 is the greatest test that we have faced since the formation of the United Nations. A virus that is oblivious to national boundaries or immigration procedures in its trajectory of destruction and pain across our world. A formidable threat to the human race, and this challenge undoubtedly requires a multilateral response for meaningful impact. And with this objective in mind, that the UN General Assembly recently had passed two important resolutions to fight the pandemic COVID-19. The first resolution recognizes that defeating the virus requires a global response based on unity, solidarity, and renewed multilateral cooperation. It therefore calls for intensified international cooperation by exchanging information, scientific knowledge, and best practices, and by applying the relevant guidelines recommended by WHO to contain, mitigate, and defeat the outbreak. And the second resolution relate to international cooperation to ensure global access to vaccine and medical equipment to face COVID-19. The UNGA reminded states to enhance multilateralism as opposed to unilateralism as a way forward, as opposed to unilateral effort to fight pandemic COVID-19. The world is going through a new phase of unprecedented moment in the post-globalization epoch since World War II. As much as it stimulates positive economic impact to many developing countries, equally globalization has facilitated the worldwide spread of diseases through the movement of people and trade. The magnitude of Ebola, Western Africa, Zika, and Latin America in the Caribbean are examples. Widespread of diseases giving rise to fears and dread in many countries for unilateral action by government to ban movement of people from certain countries from entering their countries. As mentioned by Dean, that on March 11, 2020, the WHO declared novel coronavirus COVID-19 as a worldwide pandemic. The world witnessed the unprecedented event and the unpreparedness of government over the world, all over the world, to deal with the outbreak of COVID-19 that has caused a huge number of deaths in many countries and across national boundaries. Now, as the quest for right vaccine is in its early stage, governments all over the world have decided to implement lockdowns and closing of national borders as ad hoc measures to slow down the drastic increase of the widespread of COVID-19. Inevitably, countries' economy is badly hit due to restricting or banning on movement of people and trade. Most governments are currently grappling in managing the crucial issues in the country, balancing the threat of public health and avoiding the fear of economic catastrophe. Now, another development of pandemic COVID-19 has witnessed the retrogress of regional solidarity, where xenophobic sentiments runs high, as depicted in Italy, due to disenchantment of the European Union's slow response and failure to assist the support member state to solve their public health issues. Now, due to paucity of time, my presentation will bird's eye view of globalization and its impact on health security, leading to the need to establish what we call global health governance, where currently International Health Regulation 2005 is the sole regulatory measures and is a testament of a global health mechanism, and followed by a short discussion on global health law. And finally, I will make some remarks in the concluding the presentation. And my presentation will also include some of the points that I have written in the article published in the New Straits Times recently. Now, let me first dwell briefly on the subject of contemporary globalization and its impact to the global health security. Now, what is global health security? Defined as the activities required to minimize the danger and impact of acute public events that endanger the collective health of population living across geographical region and international boundaries. Now, what we know about globalization involves changes in a wide range of social dimension, be it economy, political, technological, cultural, and even environment. It involves trade, travel, communication, relation of people, information, and much often be overlooked the new patterns of health and diseases. Now, as the world is interdependent, no country can insulate from itself from the effect. We now learn and recognize that contemporary globalization has had an unprecedented impact on global health. It has created a myriad of social, economic, and legal issues affecting so many individual states and across region. Indeed, it has created new challenges for international law and policy. It is expected in an interdependent world, through intensified movement of people and trade, the spread of infectious diseases can happen and will happen in the future. We now know that communicable diseases, which are at one time felt excessively in developed and industrial world, can equally affect poor countries. We now know, apart from states, companies too are responsible over global production of foods, which has great impact on health security. Report from UNDP and World Bank reveal the net impact of globalization that has aggravated health disparity among countries. Now I move on to what we call global health governance. Now, there is a growing concern for the need of effective mechanism of global health governance. The world community growing appreciation of the scope and scale of challenges in global health is reflected in the mushrooming of actors in global health since the founding of the United Nations in 1945. First, there has been a proliferation of international institutions active in the domain of health. Within the comprehensive UN system, organizations with significant involvement in health, including WHO, the UN Children's Fund, the UN Food and Agriculture Organization, the UN Environment Program, the UN Population Fund, the International Labour Organization, and the World Bank. Secondly, interest in global health is seen within regional institutions and international organizations outside the comprehensive UN system. Thirdly, increasing concern about global health has also been fostered by and led to an increasing number of non-state actors. Pharmaceutical industry, for example, we have a powerful influence on international health policy. Innovative health coalition involving diverse global health actors, such as health research networks, and most significantly, public-private partnership which are also increasingly commonplace and have an important influence on health policy. In addition to the proliferation of actors in international health, contemporary global health is characterized by increasing amount and sources of funding. Now, it is also increasingly understood that one necessary means of effective global health is a global health legal system, and that establishing such a system will require innovations in international law of its existing rule, institutional mechanism, and forms of collaboration. Now, let me now move to discuss the International Health Regulation 2005. Now, the Constitution of WHO proclaims the enjoyment of the highest attainable standard of health is one of the fundamental rights of every human being. The International Health Regulation 2005 are the latest manifestation of an effort in international health lawmaking that began in the second half of the 19th century, adopted by the 58th session of the World Health Assembly in 2005 in a thoroughly revised form compared with the previous version initially adopted in 1951. And they are legally binding under Article 21 and 22 of the WHO Constitution on WHO 196 member states. Now, many of us are unaware of the existence and the working of International Health Regulation 2005 as a global binding instrument of international law that has entered into force on 15 June 2007, and Malaysia is a state party to this treaty. Now, at present, 196 countries across the globe have given their consent to implement the treaty with a view to prevent, protect against, control, and provide a public health response to the international spread of disease in ways that are commensurate with and restricted to public health risks and which avoid unnecessary interference with international traffic and trade. Now, I would only highlight some of the important provisions found in International Health Regulation 2005. Now, it is said that the current 2005 International Health Regulation is a radical change from the previous version. It shifts from what they call a passive approach to a dynamic and open-ended approach based on cooperation and good faith of state parties. Now, the state parties under this regulation is under an obligation to cooperate in good faith in assessing health events, notifying WHO upon reaching certain threshold of gravity and provided detailed information and taking necessary measures. And that the state parties must achieve and maintain a set of core capacities in their national health system. Now, this is really a major challenge because in implementing the core capacities in their national health system, it requires big amount of funding. And apparently, this is where we find that there is lack of funding mechanism and that the formal mechanism for compliance monitoring is in a very loose state. Now, the next important provision under the regulation is in relation to declaration of alert or emergency by the WHO, the Director General. And we have been seeing him giving or updating the latest development in many countries and what to do and what not to do in now present danger of COVID-19. And the decision of the DG is very much act upon the advice of emergency committee composed of individual experts of public health emergency of international concern or PHEIC, and later consequential adoption of time-limited temporary recommendation. Now, this part has been very much criticized because the practice has been prone to political consideration, as claimed by many parties, and also raise question about legitimacy and transparency of the emergency committee. Now, the current system declaring of PHEIC is only at the only level, there's only one level of alert, and it is suggested that it should have more gradual alert system. Now, the other challenge of the current international health regulation is in relation to the coordination of international response. And apparently it was found to be inconsistent level and of compliance, and this need to be improved. And the next provision is where it has complex formulation under Article 43, where there are measures diverging from WHO recommendation, which states normally not able to fulfill the compliance. Now, there is also in relation to dispute settlement and Article 56. Unfortunately, there is no case today, so therefore there is no available body of jurisprudence that we can follow or to help in clarifying the limits of lawful behavior of states. And this is where there is an issue relating to binding legal nature of the regulation and apparent lack of enforcement. So these are some of the issues apparently that requires much attention, and that uh, although IHR 2005 is the sole and indispensable legal framework for global health security, it requires further reflection on the need to ensure that the issue of enforcement and compliance need to be improved very much in this area. Now, I will move on to basic what is being said under what they call global health law. Now, when we say global health law, mainly it is within the field of public international law, and which can be broadly characterized as the rules that govern the conduct and relation of countries, including their rights and obligation. So countries therefore remain the major subjects of international law, and so international organization. Now, the realm of global health law largely relates to formal sources of public international law, including treaties establishing the authority and responsibility of states for the health of their population and duties of international cooperation. And secondly, formal subjects of international law, including states and international organization. However, we want to see that this is something that after 300 years of application of Westphalian law, we have yet to see individuals being part of the subject of international law. And we know that companies too are very much responsible in promoting their business and industry in the medical field. But unfortunately, at the moment, they are not accountable under the regime of international law. And public international law primarily focus on the interaction of sovereign states and can broadly be characterized as the rules that govern the conduct and relation of states, including their fundamental rights, obligation, and commitment. While states remain the primary subject of international law, international organization, and through the development of international human rights laws, individuals are now considered, hopefully considered as subject of international law soon. Now, there are challenges of global health law, and like any treaty-based international law, with soft instrument being applied, global health law have major challenges. Now, the first is that the government are very cautious to apply full-blown rule-based system, and therefore often reject international law or agree only to weak norms. Secondly, high-income countries are reluctant to finance capacity building for lower-income countries or to provide funding to WHO without specific earmark. And third, compliance mechanisms for such laws are often weak or non-existent. And fourth, international law primarily addresses the rights and duties of countries. And it cannot govern non-state actors, which range from individual and civil society groups to foundation and private enterprises. And fifthly, coordination of governmental welfare can be difficult due to the divergent perspective and interests. International trade, for example, interest and priority of high-income countries differs of that the low and middle-income countries. Trade liberalization as against greater access to drugs and technology transfer. And six, it relates to financing resources to building capacity in order to fulfill the IHR. Now, I move on to my last topic, that is as regard to the conclusion. Now, it is evident that the current international health security regulatory system is a standalone system. The uncoordinated unilateral action taken by various governments during the pandemic COVID-19 and WHO playing a role to monitor the development of the situation is a testament that a dire need for coordinated effort between the various international organizations like ICAO, IMO, and WTO to work closely with WHO. Reform of the whole health security regulatory system must consider the feasibility of harmonizing with international transportation system, trade of goods, and movement of people. The fact that United States and most developed countries of Western Europe are unilaterally working on their own in fighting the invisible common enemy of COVID-19 clearly signal the need to establish consultative mechanism among states to multilateral effort. Now, despite IHR 2005 being a treaty, the needed reform should be hard legal instrument, leaving no room for soft instrument approach. First, there is a need to design a compulsory mechanism for alert to act much earlier, and the alert must be a built-in compulsory mechanism. Secondly, compliance can only be made possible through the availability of coordination platform between WHO and other international organizations like IMO, WTO, and ICAO. Thirdly, the UN General Assembly must play the vital role in giving the mandate to WHO to implement the coordination with other international organizations. Hence, member states must therefore give their political commitment in ensuring the successful coordination with other international agencies. There is also a need to reflect on food and agriculture connection with health security regulatory system. Much has been debated in the medical and science fraternity how human is affected by animal health and food production. The IHL 2005 must make possible to accommodate the badly needed protection for migrant workers and refugees' health security and basic human rights protection in time of pandemic, widespread of disease. And as a legally binding system for protecting people worldwide from the global spread of disease, the IHR must be seen to be complied with and observed by all the signatory states. And finally, the implementation of an effective health security regulatory system must not be limiting the sovereign right of every state. Rather, in an unprecedented moment, what is desperately needed is the cooperation and solidarity movement through science and technology diplomacy to ensure peace and health security being maintained in this world. Thank you.
Thank you. Thank you so much, Datuk. I think it was very enlightening, very informative. I would like to also share from the Lancet in February 2020, which states do not violate the international health regulations during the COVID-19 outbreak, which I think this is very much in line with what you have presented, Dato'. That this regulation reflects the role of the law in governing 196 countries and WHO to collectively address the global spread of the disease. In addition to that, it demonstrates an international initiative to address public health risk. And I'm also interested in one of your points when you highlighted the parameters of global health law within the field of public international law. And you have also highlighted the challenges which, from what I understood, the main challenge here is the acceptance of international law by the states, as well as the limitation that the international law can actually offer. So above all, what we can say is that unprecedented situations requires unprecedented measures and initiatives, and there is an urgent need of political commitment to develop cooperation and solidarity of multilateralism. And I think I would like to also quote, I take this from uh, from the NST, which was recently released, Dato'. In unprecedented times, what is needed is the cooperation and solidarity through science and technology diplomacy to ensure peace and health security is maintained in this world. I thought that encapsulates what you have presented today. So thank you so much, Dato'. We will come back to you during the Q&A session. Now, ladies and gentlemen, it's time to invite the second speaker, Dr. Shah, to enlighten us on the investment treaties, where, let me see, yeah, where Dr. Shah will generally cover whether investors have legitimate basis of claims of breach of investors' right, and what are the protections for the states that states can actually resort to. So without further ado, please welcome Dr. Shah. Dr. Shah, over to you. Dr. Shah?
Yes, can you hear me?
Yes, yes.
All right.
Okay.
Good afternoon, everyone. I'm going to highlight the topic of investment treaty disputes in response to COVID-19 measures. This is basically the paper that I recently written for the upcoming publication in the Swiss-Chinese Law Review on the special issue on COVID-19. There are 2 points that I would like to make this afternoon. First, whether COVID-19 measures imposed by states give rise to claims under investment treaty. And second, whether to whether state could defend, against such claims. What are the defenses available for states? Now, before I move further, let me give you some background facts. As the authorities across, still on the first slide. Can we move back? Yes. As the authorities across the world are implementing measures to control the spread of coronavirus, the unintended economic repercussions are beginning to affect many sectors of industries and businesses. So in view of the threat of global pandemic, states have introduced emergency measures to safeguard public health and local economies from devastating consequences of the disease. Nevertheless, some of these measures are seriously prejudicial to the operations and profit of the foreign investors worldwide. Can we move on to the next slide, please? Okay, let me give you some general overview on COVID-19 measures around the world. So in response to COVID-19 fears, many countries have taken emergency measures to safeguard various sectors that are taken aback by the pandemic. We start with construction industry. For example, China has already issued more than 1,600 force measure slips to companies hit by COVID-19 to shield them from damages liabilities. So these force measure slips or certificates exonerates companies for not performing or partial performing of their obligations by certifying that they are suffering from consequences beyond their control. In healthcare and pharmaceutical, the Indian government has decided to restrict exports of pharmaceutical ingredients and the medicines to ensure domestic stockpiles. Although recently the Indian government has made a U-turn due to a threat by Trump and Brazil. In the same sector, Spain has allowed government interventions in healthcare and pharmaceutical sectors. In property and banking sectors, Italian government has allowed requisition of property and suspension of payment under mortgage loans. And a more desperate attempt to salvage the economy from sinking has seen the nationalizations of airlines in Italy. In Peru proposed measures to suspend toll fees collections on the country's road network, likely to invite multiple claims under ICSID, which stands for International Center for Settlement of Investment Dispute, which is an arbitral forum under the World Bank. So in view of these measures, foreign investors could potentially claim that they're affected by the state emergency measures. Can I move on now to the next slide? Thank you. Now, on the first issue, how state measures likely give rise to claims under investment treaties. So to what extent state measures give rise to investment treaty claim depend whether or not measures are imposed in a manner that breach the treaty substantive protections. So these are the underlying parts are the treaty substantive protections. First, on the uncompensated indirect expropriations, I mentioned Italy just now. If the requisition of property is implemented on permanent basis, the investor could argue on the basis of uncompensated indirect expropriations. Next, fair and equitable treatments. A non-permanent measures such as suspension of concessions, like in the case of Peru, or restriction on export in the case of India and Spain, might lead the investor to argue that such measures defeat its legitimate expectation to be treated in a FET manner. The third is full protection and security, where investor could also assert a breach of FPS when the governmental regulatory acts interrupt the legal stability surrounding its business. Can I move on now? There are two more possible breach of treaty substantive protections, such as breach of national treatment, where the investor could invoke on discriminatory ground where the government provides assistance to domestic investor without the same being made available to the foreign investor. And finally, a breach of umbrella clause. If state fails to comply with its contractual obligation, the investor might assimilate a breach of contract to the breach of the treaty itself. I would like to move on now to recap the substantive protections of investor under the treaty, investment treaty. Now, these are the grounds in which investor could make in order to hold the state accountable for the breach of its substantive protections. First, the right to compensations for direct indirect expropriations. Second, the right to fair and equitable treatment, FET. Third, the right to full protection and security, FPS. And finally, the right to national treatment. Can I move on now? All right. Having mentioned about the possible breaches of treaty substantive protections, now I would like to draw your attention to the next issue on the defenses. What are the defenses available for states? In other words, how state could defend against such investment claims? There are two defenses available for state. First, exception clauses or the carve-out provision under the treaty itself. So investment treaty here consists of BIT, bilateral investment treaty, and also MIT, multilateral investment treaty. And the second is defenses available under customary international law. Now we start with defenses under the BIT, MIT first, on the exception clauses. So exception clauses excludes measures taken by the contracting state in the fulfillment of their obligations relating to variety of public interest. And some of those clauses especially exclude measures to protect public health from application of the relevant treaty. So in other words, exception clauses or carve-out clauses allow state to impose treaty inconsistent measures without being held accountable for its action as long as the measures in question are not arbitrary or discriminatory. So this brings me to the next slide. Let's look at the examples of exception clauses in the bilateral investment treaty or multilateral investment treaty. I'll start with CETA first, Article 28.3, Clause 2, Paragraph B of the Canada-EU Trade Agreement known as CETA 2016 contain exceptions allowing states to take measures aimed at protecting human life or health, as long as they are not arbitrary or discriminatory, without implying a breach of international law. Next is China-Australia FTA, Free Trade Agreements. Now stay on the previous slide, please. Okay, Article 9.11, Clause 4 of the China-Australia Free Trade Agreement 2015 goes even further, providing that non-discriminatory measures implemented for legitimate public welfare objective shall not be subject of a claim. Shall not be subject of a claims from the investor whatsoever. Next slide, please. Let's look at more examples in relation to state right to regulate. If you look at the new generations of the BIT, such as closer to home, we have CPTPP, Comprehensive and Progressive Trans-Pacific Partnerships, formerly known as TPPA. Paragraph 9 of the CPTPP preamble says that parties to this agreement resolving to recognize their inherent right to regulate and resolve to preserve the flexibility of the parties to set legislative and regulatory priorities, safeguard public welfare, and protect legitimate public welfare objectives, such as public health, safety, the environment, the conservation of living or non-living exhaustible natural resources, the integrity and stability of the financial system, and public morals. Moreover, if you look at the investment chapter under the CPTPP, Article 9.16, Investment and Environmental Health and Other Regulatory Objectives, it provides that nothing in this chapter shall be construed to prevent a party from adopting, maintaining, or enforcing any measure otherwise consistent with this chapter that it considers appropriate to ensure that investment activity in its territory is undertaken in a manner sensitive to environment, health, or other regulatory objectives. And there are two more examples in the next slides with regard to state right to regulate. Article 6.3 of the Comprehensive Economic Partnerships Agreement between the EFTA states and the Republic of Ecuador, 2018, provides that nothing in this chapter shall be construed to prevent a party from imposing, maintaining, or enforcing measures necessary to protect human, animal, or plant life or health. And the last one, Article 15.1 of the Hong Kong-Chile BIT, 2016 provides that nothing in this agreement shall be construed to prevent party from adopting, maintaining, or enforcing measures otherwise consistent with this agreement that it considers appropriate to ensure the investment activity in this area is undertaken in a manner sensitive to environmental, health, or other regulatory objective. Can we move on to the next slide, please? So those were the exclusion clauses or carve-out provisions in the BIT-MIT that exclude states from being accountable for the measures it takes with respect to public welfare objective. Now, let me move on to the second allowable defenses for state to shield against the investor claims, which is found under the Customary International Law based on the International Law Commission's ILC draft articles on state responsibility 2001. So let's start with Article 23 on force measure. So force measure is a situations arises where three elements are met. First, the act in question must be brought about by an irresistible force or an unforeseen event. Second, which beyond the control of state concern. And third, which makes it materially impossible in the circumstances to perform the obligations. Now, there is a widely held view that IFC draft articles actually reflect customary international law. All right. So the IFC draft articles provide defenses such as force measure and also necessity that I'm going to move on later, known as circumstances precluding wrongfulness of conduct that would otherwise not be in conformity with the international obligations of the state concerned. However, a defense of force measure will not succeed, or rather will fail, if state merely find that a performance of its obligation become more difficult or burdensome due to political or economic crisis. So this was illustrated by the arbitrary tribunal in Rainbow Warrior case between France and New Zealand. Now, having said that, state might justify its measures by pointing out to COVID-19 as unforeseen event beyond their control that cause a non-performance of obligations. And if you look at the discourse in construction law, construction industry, force measure has been the order of the day where argument is based on force measure to release the contractors, for example, from not performing their obligations due to COVID-19. All right, so let me move on now to second available defense under customary international law based on Article 25, necessity. So necessity is a term to denote exceptional cases where the only way a state can safeguard an essential interest threatened by a grave and imminent peril is, for the time being, not to perform some other international obligations of lesser weight or urgency. There are two cases here, CMS Argentina 2006 and also another 2006 case, LG&E Argentina. Why I put these cases? Because a plea of necessity is notoriously difficult to prove. Just like a doctrine of frustration under contract law, it's very, very difficult to prove because of a high threshold that the tribunal imposed in past cases. And there are very few cases that succeed on necessity plea. I start first with CMS Argentina. The tribunal found that the two requirements of a finding of necessity were not met because the measure taken by Argentina were not the only way, because there are other alternatives to cope with the situation, and Argentina itself had contributed to the situation. So plea of necessity in CMS Argentina failed. However, the tribunal took a different view in which the plea of necessity was accepted for a limited period in LG&E Argentina. Now, why tribunal took a different view in LG&E Argentina, in contrast to CMS Argentina? Because in LG&E Argentina, the tribunal found that the emergency measures imposed by the Argentine government was the only way available, and the fact that the Argentine government did not contribute to such an economic crisis. However, the successful plea of emergency does not waive state from its obligation to resume performance after the situation of emergency ceases to exist. So a high threshold to demonstrate necessity as seen in many cases, one of them is CMS Argentina, where the tribunal find that state failed to satisfy the two stringent requirements, which are the only way and non-attributions elements. All right, let me move on to my last slide, but I got something to conclude in the end. Another defense that available for state is a police power doctrine. So this is not based on customary international law or the RC draft articles, circumstances precluding wrongfulness, but police power doctrine is widely used in investment treaty arbitrations. Police power doctrine basically explains that a state has a power or capacity or ability to regulate behavior or enforce order for the betterment of public health, even morals, and public welfare objective. Now, let's look at Philip Morris Uruguay case in 2016. This is the case regarding the measures or the regulation imposed by the Uruguay governments, which require the Philip Morris, the cigarette company, to use plain packaging cigarette pack in order to discourage smoking habits. So the tribunal in Philip Morris Uruguay found that the state reasonable bona fide exercise of police power in such matters as the maintenance of public order, health, or morality excludes compensations, even when it causes economic danger to an investor. Let me refer to the words of the tribunal in Philip Morris Uruguay at para 399 of the award dated 8 July 2016. It says that the tribunal agrees with the respondent, Uruguay, that the margin of appreciation is not limited to the context of ECHR, European Convention of Human Rights, but applies equally to claims under the BITs, at least in the context such as public health, because it involves smoking. The responsibility for public measures rests with the government, and investment tribunals should pay great deference to governmental judgment of national needs in matters such as protection of public health. So, based on police power doctrine, state could argue that the measures imposed stem from its sovereign power to regulate. I mentioned a few times, based on the examples in the BIT, MIT clauses that recognize state right to regulate for the benefit of public order or health. So, state will also likely to assert that the tribunal should pay great deference to governmental assessment of national needs. Therefore, the tribunal should be slow to intervene in the state measures in times of crisis. However, the margin of appreciations jurisprudence is far from settled, because there's an argument, there's a counter argument to that. In Peso Zimbabwe case, for example, 2015, where the tribunal declined to apply the margin of appreciation doctrines unless expressly embedded in the treaty itself. So, according to the tribunal in Peso Zimbabwe, which is not in the slide anyway, the doctrines of police power had neither found much support in international investment law nor achieved the customary status. So, it has to be applied with caution. Otherwise, the exercise of public power doctrine is going to empty or going to render the investment and investor protection under the treaty meaningless. All right, in a nutshell, it's not difficult to anticipate that there will be a number of investment claims post-COVID-19 pandemic due to various emergency measures imposed by the governments around the world. It's safe to say that the best line of defenses, in my opinion, is the exception clauses, the carve-out clauses under the BIT or MIT. Even though the treaty do not contain such exception clauses, state can still rely on customary international law defenses, in particular force measure or even police power doctrines. Having said that, a plea of necessity is, I would like to reiterate my words, notoriously difficult to prove, where the threshold is very high based on past cases that state could satisfy the stringent requirements of the only way and non-contribution elements. So that brings me to the end of my presentation. Thank you very much.
Thank you, Dr. Shah. So basically, ladies and gentlemen, it was a very insightful knowledge Dr. Shah has shared with us. He has highlighted mainly the economic impact of emergency measures taken by the states, particularly from the perspective of investment treaties. So basically, in many countries around the world, non-compliance with emergency measures is subject to criminal sanctions. As such, businesses have been required to take difficult decisions that will have a significant impact on their day-to-day operation, as well as their future financial viability, which leads to the claims made by the investors. So given this unprecedented scope of such measures in peacetime, investors and states should be aware of how their rights and obligations under investment treaties and other investment instruments may be impacted by these events. And Dr. Shah has also highlighted what defenses might a state have. So even if an investor were able to establish that there has been a breach of an investment protection right, state parties may nonetheless have one or more valid defenses of claims of violation of investors' rights. So I hope I have pointed out the main points by our learned speaker. So, ladies and gentlemen, we have now come to the question and answer session, and I am very pleased to see so many questions from the audience. Thank you so much. I will start with the first question. This is a question by Puan Lisa Halila. She's currently a lawyer at Zurafik. She was previously in Bank Negara Malaysia. Thank you so much, Puan Lisa, for joining us. This is a question for Yang Berbahagia, Prof. Dato' Rahmat. In addition to political will or commitment, financial or economic standing also affects the extent of countries' compliance. How would countries affected by recession be able to prioritize their financial needs and demonstrate full compliance, which may be costly? Dato', over to you.
Yeah. Yes, thank you. Thank you for the question. I fully agree with you that full compliance would mean that countries would have to spend money to build their capacity. So in fact, this is one of the concerns of scholars in this area, that as much as WHO and under the international health regulation would like to see that it is very much a state matter, that state would have or must in a way build the capacity, but capacity would also mean money, and it is not cheap. And we in fact hear a report recently as regard to COVID-19 that one poor country in Africa would only I think can only supply one ventilator. I mean, that is the state of economic status for these poor countries. So compliance would, in this case, have to look into the capacity of each state. And it has also been stated by or reported by World Bank and also UNDP that globalization has caused further deficits, or there is a wide gap between rich and poor nation, and despite the fact that many non-state actors are actually spending a lot of money on health issues, but still, it does not solve the issue of especially building capacity, especially in relation to diseases. Yes, I think that I agree with the question just now. It's not easy to have full compliance.
Yeah.
Yes,
Okay.
that's
All
it.
right. We move on to the next question. Also to Yang Berbahagia Prof. Dato'. You did mention that nation has responsibility to inform the WHO regarding the potential threat of the pandemic. Do we need a universal guidelines which is in line with the principle of use go chain and again omnes? Second, by having safe principles in international health law, can we punish the nation which failed to protect the life of international citizens? Okay, Dato'?
Thank you for the question again. As regard to universal application, I think in public international law is very slow in trying to accept matters of this concern uh, to be of universal application unless probably in the realm of customary international law. But as regard to treaty, the principle of just cogent or erga omnes is quite difficult when we know that if we're going to enforce universal application, then there is an issue of capacity building again, you know, like whether poor country can cope with, for example, having the latest technology, having the latest scientific methods, which is very costly, and this is actually the prerogative of many developed world. So if we're going to apply this, then it may affect poor countries, and in that sense, I I, I have a dispute as regard to its universal application. Of course, I would love to see that 196 countries being signatories to international health regulation should in fact be almost universal, but still issues that need to be resolved here, you know. And your second question as regard to punishment, whether a state can be, you know, international health regulation, unfortunately, is not geared towards punishing state, and it has no provision as regard to punishment, and this is where it appears that as regard to compliance and enforcement, it fails as a treaty that I would like to say. This is not like where you have ICC, for example, the Rome Statute, where you can have a situation where if the state is unwilling or unable, then, for example, the Hague, ICC, the Hague will take over the prosecution. This is not like that. In fact, if you read the history, the history and where the committee was set to look into what extent it should be what would be the extent of the law applicable, and they would say that this is very much a state call, you know, rather than let state develop, have the building capacity, and then from there they will move on to another level. So unfortunately, it is not like that. Um, that they do not have the jurisdiction to punish the state. Thank you.
Okay. Right. Thank you, John, for the question. Next question, also to Dato' from Ahmad Zulhazik. In relation to COVID-19, what are the types of countermeasures that Malaysia can possibly take against China without having to jeopardize our bilateral relationship? Dato'?
Yeah. Again, thank you for the question. I did ask the person who asked the question: is it related to trade or is it related to to COVID-19.
COVID-19, yeah.
Obviously is related to COVID-19. Now, if you look at the possible remedies for states, yeah, we have, for example, the famous trail smelter arbitration case between Canada and US, where in that case, it was decided that no nation has the right to use or require its territory to cause harm to another territory, and that the polluting state has to compensate, because this is regarding pollution. And of course, in that case, the Canada have to pay US reparation. And the other remedy is in relation to draft article of wrongful act under the responsibility of states. And also you have some of the provisions under international health regulation. However, we must take note that I know that in the midst of pandemic COVID-19, there are issues, there are questions raised by many countries whether they could pursue and, for example, sue China. They said it was China who started this COVID-19. There was very much, the report came late, and the action taken by Director General of WHO was also quite late, so on and so forth. These are criticism made by some countries. But as far as Malaysia and China is concerned, I think it is very much not just the law, but also in relation to the diplomatic relation between Malaysia and China. Of course, we have to prove. There is a question of evidence. Is it true that it all started in China, in Wuhan? That we do not find. In fact, WHO did not make it clear on that, whether there is a confirmation of that coming from Wuhan. So it's not as easy as that. That the country can, simply take action. There is another avenue. You can bring the matter to ICJ, but I doubt whether it will go to that extent. So, as I said, this is very much a state matter, and I think state would have to take the necessary measures to ensure that the diseases or the cause of disease actually is coming from that state. That is why there is a need for notification. It's very important under international health regulation that the state has a duty. It is obligated. Yeah? In fact, stopping or prohibiting movement of people before the enforcement of emergency declared by WHO is also an offense. Is an offense under international health regulation, and we see that many countries have done this. They are actually in defiance of that law. But there is a question of enforcement. There is a question of compliance here, and it appears that IHR is weak on this part. Thank you.
Thank you, Dato'. Another question for you. You mentioned that states are under a compulsory obligation, or maybe I pose a question to Dr. Shah first.
Okay.
Then
Right.
I'll come back to you. Yeah, Dato'?
Yeah.
Okay. Question to Dr. Shah. This is from Izati Nadira. When a state claims that what they are doing is for public interest as an excuse to the investors, and they rely on such an exception in their bilateral investment treaties or multilateral investment treaties, is there a period attached to such exercise? Would it be okay if the measure lasts until next year? Dr. Shah, over to you.
Okay, can you please repeat the last part of the questions?
Would it be okay if the measure lasts until next year?
Okay. So there is temporary measures. Now, if state rely on the exception clauses in the BIT that enter into between the host state and the home state of the investor, then state has legitimate, justifications to impose such measures. I give you example just now, China, Australia FTA, where exception apply in areas related to public interest that totally excludes the claims made by the investor. So there's nothing much investor can do about that. Now, assuming another scenario where there's no such exception clauses in the BIT, and because you mentioned measures until next year. So assuming these temporary measures, what investor can do is to rely on the breach of its substantive protections under fair and equitable treatment. Because under fair and equitable treatment, state is entitled to expect that, because under fair equitable treatment, investor is entitled to expect that the state will not act in non-transparent, inconsistent, or discriminatory manner. So that is my answer to that questions.
All right. Another question for Dr. Cha. Okay, from Hakim Halim. When you mentioned margin of appreciation in Philip Morris versus Uruguay, what would that actually mean in brief?
Well, margin of appreciation actually refer to the power of the states to impose emergency measures in times of crisis, such as economic crisis or the pandemic, the global pandemic, where the state know best. The state know best to protect the interests of its inhabitants, of its people, in terms of environmental protections, for example, or public health. Since state know best, therefore, the tribunal should be slow to interfere with the state measures in time of crisis. So that is the margin of appreciation. However, as I mentioned, the margin of appreciation's jurisprudence is not settled, because there's another counter argument to that, as we found in the case of Pezol and Zimbabwe, 2016. Because you have to apply margin of appreciation with cautions, or otherwise, it would render the investment and investor protection under the treaties meaningless if state measures are not subject to challenge by the investor. So in Pezol, Zimbabwe, the tribunal declined to apply margin of appreciation doctrines, police power doctrine, because the tribunal could not find support in international investment claims or in customary international law.
Okay, thank you, Dr. Shah. And the last question for Dr. Shah before we come back to Dato. In a situation where a contract is silent on the clause of forced merger, what is your opinion? Will Malaysia court consider forced merger under customary international law? Dr. Shah?
Okay, interesting questions, because there are two different scenarios when it comes to forced merger clause. I've been talking about the forced merger clause within the context of investment treaty. Now, let's look at the forced merger issue within the context of domestic law. Let's take an example of construction contract, because it has different meanings, from investment treaty and also from domestic law construction contract. Now, assuming the construction contract between the developer, the employer, and the contractor is silence on forced merger, which is not anyway, because I found that most of the construction contract in Malaysia cover forced merger situation. And to some extent, it specifically lists epidemic as part of the forced merger scenario. Now, coming back to the question, if construction contract silent on forced merger is too bad, we cannot apply customary international doctrine in Malaysia, because the approach of Malaysian courts, unless the customary international law is incorporated in the statute, then it will not bind the courts at all. So the court will likely to ignore such arguments based on customary international law. We saw that in one of the case, PP Narwan Supawits, where Mahathir Shankar, JCA at the time, court appeal, dismissed the customary international law doctrines of right innocent passage, on the case where the Thai fishermen illegally trespassed Malaysian territorial water to fish, just because right innocent passage was not incorporated in Malaysian statute. Now, what can the aggrieved party do in the absence of force majeure clause in the contract? We are talking about construction contract, right? Is to move on to the next doctrine of frustration. However, doctrine of frustration is notoriously difficult to prove. that will likely not to succeed at all because of the high threshold on frustration, where the subject matter of the contract has to be destroyed in order to release the parties, in order to rescind the contract and release the parties from their further obligations.
Okay. Right. Thank you, Dr. Shah. Dato, I think there are more questions for you, Dato. This is from Akmarul Akil. He has two questions for you. The first question, you mentioned that states are under a compulsory obligation to strengthen surveillance and response capacities. What are the measures that can be taken if states fail to do so, Dato?
Thank you for the question. It is true that there is a compulsory obligation for the state to strengthen surveillance and response capacities, and very much, as I said, state obligations. Unfortunately, at the level of WHO and international health regulations, if state fail to do so, there's not much, as I said, form of punishment can be discharged, or the state will. It's difficult for WHO or IHR in that matter to find the state failure and, for example, being paid compensation or in that form. There is no such provisions under the Regulation 2005 at the moment. But as I said, there are other options that are available under the state responsibility draft article, state responsibility, bringing the matter to arbitration, or even under dispute settlement measures under international health regulations. So to put it bluntly, unfortunately, there is no such measures under IHR against state failing to comply to the obligation.
Okay. Another question from Akmarul, Dato.
Yeah.
We saw that the United States suspending funding to WHO as they blame them for mismanagement. With that said, would the international health regulation be able to be properly used for effective management during this pandemic, when states can interpret actions of other parties as insufficient and choose to not follow the IHR?
Yes, of course. When US suspended their funding to WHO, that caused a lot of problems to issue of finance. Yeah, and then US is noted for that. They pull out from the Paris Agreement, the Rome Statute of ICC, and these are very much a situation where once you are in, then you are out. You are actually not following the requirements of international treaties. A big chunk will come from United States and other European countries. So when that happens, then that will have less. It will mean less money for WHO and IHR to regulate, to ensure that state will apply to the regulations. And of course, it's always a question of funding. And if you have less funding, then there will be not much activities or initiative that can be done by the organization.
Okay, thank you, Dato. I think this is a question for Dr. Shah. What recourse do parties have if states justify its measures by pointing out that COVID-19 as a force majeure? Where does it leave the parties? Dr. Shah?
Okay, the recourse available for parties, even if state justify its measures, as deriving from force measure, is to in the case of expropriation, for example, is to look at whether state has given adequate, prompt, and effective compensations. Parties could still go for compensations. Compensation may not be adequate, compensation may not be prompt, compensation may not be effective, although there is compensation. So that would be the record for the parties to look for.
Okay. Thank you, Dr. Shah. And we have another question for Dato. Provided in the ICJ case of Gevshikovo, Negimaros, Hungary versus Slovakia, and the advisory opinion of nuclear weapons, that a country bears the obligation of preventing activities within its boundary which may harm the environment of another country or other areas which is beyond the country's control. Is it possible to hold China responsible under the international law on its refusal and failure in regulating the world meat industry, which led to the birth of COVID-19?
So thank you for the question again. I've mentioned the case of Trail Smelter arbitration case between Canada and US. Of course, if the country is found to be using something that can cause harm to another country, in the case of Trail Smelter is in relation to pollution, if you can do so, and compensation can be made against the state that has caused the pollution or harm to the environment. Bearing in mind, China was also found to be a state that has caused environmental degradation in South China Sea at the Spratly. That can be done. Yeah, no, I don't think there is this avenue of where you can go to court, you can go to ICJ or to arbitration. But however, one have to take note that in the area of what we call real politics, country like China may not want to enforce, as you can see in the arbitration between China and Philippines, where China refused to acknowledge or recognize the decision made by the arbitration. Yeah? And first of all, you have to prove the existence of that harm in China, and of course it's a question of political will. This would fall into a different realm, not under international law. Of course, as I said, there are a lot of remedies available under international law, and the other one is in relation to the draft article of state responsibility, which you can bring in another state that cause harm to environment. But at the end of the day, rule-based approach may not be the best method to ensure a long-lasting relationship between states. And I am one person who advocates negotiation and conciliation rather than going to third-party or arbitration or the courts.
Okay.
Can I add on a little bit to that question?
Yeah. Yes, Dr. Shah.
All right. Well, usually states are not keen on, going against the mighty Chinese government because of the fear of retaliations. You can see that in investment treaty arbitration, there are very, very few cases where China has been the respondent. Only one or two cases. Unsung case where Korean multinational company took Chinese government to exit, and another case involved Malaysian contractor who took the mighty Chinese government to exit. However, it was withdrawn before the case was heard. It's not possible to go against the mighty Chinese government because of many factors. First is the legal cost is not cheap. Taking Chinese government to arbitration is not cheap. Who funded Philippines during the PCA arbitration was the USA during the Barack Obama time. And how could state, support financially the arbitration proceeding when states, around the world are struggling and they're grappling with the, economic recovery because of COVID-19. So it's not cheap. The legal fees can be exorbitant, can be massive. Thank you.
Oh, yeah. Thank you so much, Dr. Shah. Indeed, it's not cheap. Maybe to Dr. Shah, I came across an article on protecting against investor state claims amidst COVID-19, whereby governments are facing an imminent threat of investor state arbitration. One of the solutions is for governments to suspend treaty-based investor state arbitration for all COVID-19 related measures. What is your view of withdrawal of consent? Can government withdraw consent to investment arbitration until a multilateral solution is found? Dr. Shah?
Thank you very much for the questions. On the suspensions of multilateral treaty, it was done in the past by international government. It was done by the Indian government. It was done by South Africa governments. Because of the nightmare being taken to exit claims that involve huge claims put by the investor. But in my opinion, it's not advisable to do so at the moment because it's going to be, very, very sudden. Withdrawal of consent can be challenging too. You don't withdraw the consent, in time of crisis. You can do that afterwards. But the thing is, if you withdraw the consent, like some states in South Africa, Bolivia, what else? Bolivia, no, Argentina, Bolivia. I try to recall, some state in South America who withdraw the consent because of the fear, because of the bad experience dealing with ISDS arbitration. But if you withdraw your consent, you actually, moving away from the trend. And bear in mind that even for developing states like Malaysia, we could also be the investor as well. Malaysian investor invest telecom, for example, in Ghana, where we involved with the Ghana governments, MTD, Chile case, Telecom Ghana case. So if you withdraw the consent, then you are actually isolating yourself from the protections under the BIT, especially when you have your investing overseas.
Okay, thank you, Dr. Shah. And last question from Professor Erwin to Dr. Shah. What can an investor do if the host state prohibits export of a COVID-19 vaccine or other related treatment because it wants those medicines for itself?
Thank you, Prof. Erwin, for your questions. Yeah, India has done that. Recently made a U-turn after a threat by Donald Trump in Brazil. The Indian government, immediately lifted the ban of its medicines. It imposed a ban export of the medicine because of the local needs, domestic needs of the medicines of its own people because of COVID-19. Now, if that happens, I suppose it happens on a temporary measure where the export ban on medicines or pharmaceutical products are going to be lifted, supposed to be lifted after COVID-19 measures over. All right. Now, for this temporary measure, what investor can do is to rely on the breach of FET, for equitable treatments, where based on FET doctrine, investor is entitled to expect that the host state will not act in a manner that is manifestly non-transparent, inconsistent, unreasonable, or discriminatory. But there's a counter-argument to that because state could argue that, well, you have legitimate expectation, but you cannot expect the state law to remain static forever. State as sovereign entity has power to amend the law based on circumstances, like COVID-19. For that purpose, I think we have to, again, look back the meaning of FET, fair equitable treatment, as espoused by the Tribunal in Saluka Czech Republic case, where FET, where the tribunal emphasized FET terms on consistency, transparency, and reasonableness of the state action. Now, another dimension of issue coming together, for which are FET, investor can argue whether or not the measures was implemented with due process, whether a sufficient notice was given, for the investor to make adjustment of their investment. So This brings another dimension of issue that involve examination of state measures, whether it was done with due process of the law. I hope that answer Professor Irwin's questions.
Okay, thank you, Dr. Shah. And this is the very final question for Dato from Professor Irwin. Is the threat of the US to withdraw WHO funding a breach of its treaty obligations? Pacta sunt servanda. Dato?
Yeah, thank you, Professor Wayne. Valid question. Of course, under international law, the maxim pacta sunt servanda is very important because once you become a signatory to a treaty, you must therefore follow the treaty with faithfully. If that is the case, then US would be guilty of that for not honoring the important maxim of pacta sunt servanda. But as I said earlier in my answer to one of the questions, we know very well that there are a few incidences where US pull out from the treaty that they have already signed. One is in relation to the Paris Agreement on climate change. And the other one is in relation to the Rome Statute of ICC. So the rich country undoubtedly will have to put in big amount of funding to ensure that organization survive and be able to sustain. The fact that US withdrew from WHO, of course, would then the fund or the funding of WHO. As I said, it is clear that if we say that they have failed to observe the maxim of pacta sunt servanda, then obviously they are into that. But again, you must understand the withdrawal of treaty is actually a sovereign call. No international organization would in a way say that you are guilty and you have to do this or that, because what makes international organization effective or sustainable is actually the members, and that very much depend on whether the states would be a party to that organization and how long they want to be that. That is a sovereign call, and if that happen, of course, many countries are not happy, but the reality is that there must be good reason for US to pull out from WHO or from very much a state matter. So this is the biggest challenge of international law, really. So that would be my answer.
Okay. All right. Thank you so much, Dato. Thank you so much, Dr. Shah. I think we've covered all the questions. It was a very productive Q&A sessions. I think we've received more questions than when we have a physical talk series. So basically, we have reached the end of our webinar series session today. Everything that has a beginning, that has an ending. Before I pass to the MC Sarah, I would like to express my gratitude to our audience. Basically, we have our students and we also have colleagues from all, not colleagues from UITM branches, campuses, and then we also have practitioners. Thank you so much for joining us. You're being so attentive and responsive in our session today. And thank you so much to our organizing team for going through thick and thin to ensure the smooth running of our event. And most importantly, to our esteemed speakers for sharing such valuable knowledge with us today. I hope this session will impact everyone in the best possible way. Till we meet again in our upcoming webinar session, and I would also like to take this opportunity to wish all of you selamat menyambut Hari Raya. Kita akan menyambut Hari Raya dalam beberapa hari lagi. So selamat menyambut Hari Raya, and please do not leave the meeting room yet because we have the photo session after this. So once again, thank you so much, Dato. Thank you so much, Dr. Shah. Thank you everyone. Such a wonderful session. And Sarah, over to you.
All right, okay. Thank you, Dr. Harithini. So thank you to both of our speakers for today. It was indeed a very informative speech. And with it, we have all gotten a glimpse into the application of international law during this global pandemic. And now, before we end the event, I would like to invite the keynote speakers, the dean, as well as the audience for a photo session. So you may all open your camera now.
Is that right? Is that okay?
Yeah. Can you please turn on
This is my first time.
the visual mode?
Okay. So everyone move their camera.
Can you see me?
Yeah. I can see everyone. So it would be on a count of three. I will take a photo. Right. 3, 2, 1. Right, okay. That's with that being said, our event will come to an end. Please don't forget to fill in the evaluation and attendance form. Thank you everyone for joining us today. We hope that you have a pleasant day. Assalamualaikum.
Waalaikumsalam.
Bye everyone. Thank you so much. Thank you for joining us. Bye.
Bye.